delighted to be recording this case study today with INHOUS, plus some very special guests, talking about a case of a famous sports star who's going through a divorce. Before I get into the details of the case study, I'm just going to come to each of our contributors for a short introduction about themselves. So first of all, Adam Osper from Tilney. Welcome, Adam. Nice to see you. Be great to hear a little bit more about yourself and your practice at Tilney.
Sure. Thanks for having me. I work for Tilney. I'm one of the partners in the practice. I have been working in the sports and entertainment space for 13 years now, and predominantly client bank are professional footballers, musicians, and then a handful of tennis players, golf, boxing, and other entertainment people.
Terrific. Well, thanks to have you. Great to have you with us.
Thanks for having me.
And Rose, great to have you with us. Be interesting to hear how INHOUS work with sports and entertainment clients.
Thank you for having us, David. I suppose the most important thing for high-profile individuals, whether they be sporting or in acting and so on, is that we shield them from the process and we maintain that discretion throughout, whether they're buying, whether they're selling. There's no need for that to hit the papers, to be in the media, or for them to be taken advantage of in any way. And therefore, we can be an independent advisor in between them and the transaction and manage it throughout.
We're also joined by Jessica Smith from Howard Kennedy in London via Zoom. Welcome, Jessica. Be great to hear a little bit more about your practice and how you work with sports and entertainment clients.
Hi, so I'm Jessica Smith. I'm an associate in the family team at Howard Kennedy. As a firm, we have a lot of sports professionals and other high-profile individuals as our clients. Obviously, this case relates to family law, which is why I'm here. When we're advising sports clients, one of our key priorities for them is protecting their future, because obviously as a sports individual, most of your money-making years are in your early 20s, all the way through to maybe your early 30s. And obviously during that time, you're stockpiling cash, and it's very important that you're doing sensible financial planning so that that money can last you for the rest of your life in many cases. So that would be something that we deal with quite often at Howard Kennedy, which is why we are involved in this case study today.
So just turning to the details of the case study, we have here the case of Sandrine Laurent, who's 35. She's a recently retired French female tennis player who lives in a townhouse in Chelsea and is getting divorced. The player now has a lucrative media career with a 7-figure annual income generated by commentary appearances and endorsements. These contracts are managed via a trust and company structure in Malta. She has been resident in the UK with her family for 10 years. She has 2 kids, aged 8 and 6, with her husband, and has been married for the last 12 years. Her husband has been the main carer for the children of that time with no income of his own. She inherited some wealth recently, and her asset base includes a €2 million villa in Provence, a £10 million property in Chelsea, €5 million of investments managed in Switzerland, a £1 million pension in the UK. Following their divorce, in the medium to long term, she would like to return to France and her husband would like to stay in London. So Rose, just turning to you first, I mean, how might INHOUS work with a client, a high net worth client like this going through a divorce?
I would say the most important thing here for them is that they have an independent advisor who can give good advice to both parties and to the lawyers involved and get consensus in the process on how we move forward. So if we get agreement from the outset on the best course of action and manage it discreetly and hold their hands through the process. Obviously a divorce, it's a very stressful situation. If we can remove some of the stress and some of the emotion for those clients and just deal with the property transaction on their behalf, it will take one aspect of the challenge ahead of them, off their plate.
Okay, great. And assuming both parties want to sell the Chelsea property, how would you help them achieve the maximum sale price?
Well, I think, one of the first steps there is to get the valuation right. So how we conduct it is we'd ordinarily have a valuation synopsis done. So we'd invite in a number of hand-picked agents who are very active in the Chelsea market, invite them in to do the valuation day. We shield those clients from the process. So we would attend the property, meet with the agents, get some advice on their pricing strategies. Then we collate that information, report back to both husband and wife and to their lawyers and try and get consensus on the pricing. Once we have that, then the process is reasonably smooth from there. It's one of their biggest assets when you're naming the assets. The property in Chelsea, it's so important that we maximise the value. But on the flip side, that we don't overpromise a value and then leave a property sit on the market. So we would intend to maximise the sale price without overpromising to anyone and causing more issues within the transaction.
Because the valuations at this level is subjective, isn't it? So getting it right is not clear as selling a lower value asset. There maybe is a clearer market price.
Absolutely.
Tell us a little
it
bit more on that.
It can be difficult to get the exact comparable evidence because properties at this this point in the market, it really depends on demand at any given time, but also how much supply there is on the market. Also, it'll depend on how much the agents are really keen to win the instruction, and sometimes they are tempted to maybe put a higher price on it in order to win that instruction from the client. I suppose it's that kind of knowledge that we have and experience that we have in the market that can shield the client and give them independent advice. So get the information, collate it, bring them the comparable evidence, and make sure that we have a good spread of information for them, and then, collate it and present it as a report so that they can make the decision based on the facts.
For clients in the public eye, sports and media clients, the discretion side of dealing through an agent like INHOUS or working with INHOUS to sell this property is very important. So perhaps you could tell us a little bit more about how you would differ from dealing with a regular agent in that respect.
Well, we understand, they're high-profile individuals. They're going through quite a sensitive time. I think, not disclosing the circumstances of the sale to any of the parties involved is quite important. So there's no need for agents to know that it's a divorce. There's no need for the agents to know who the identity of the client. And we're very careful to shield our clients in that way.
And finally, how can you ensure that the buyers looking to view the property have the intent, the capacity to go on and transact?
Well, really, at this level of the market, we find most buyers have a representative, so they've already hired a buying agent. And if they've engaged with a buying agent, that buying agent will have done their due diligence. We could well have crossed paths with the buyers, that are interested in this property previously, because it's quite a niche, pocket in the market. And we trade quite a lot at that level. So we could well have crossed paths with them. If not, they'll usually have a buying agent. Failing that, we'd usually look for proof of funds or do some further due diligence ourselves via their wealth manager, via their solicitor or one of their advisors. So we try and do as much groundwork as we can before we let the buyer in. And if we had any hesitations, we'd resist.
But if they've engaged a buying agent, it's a good signal of intent. It's probably a known party to you. You know there's a deal there to do.
Oh, absolutely.
Yeah.
They'll already have, spent some money up front.
Yeah.
You very much have the intent. And it's a small world, really, in that section of the market. So we'll know them.
Great. Terrific. Adam, just coming to you for looking really at the financial aspects. There's a broad asset base here, differing circumstances of the parties on divorce. Just looking at from Sandrine's perspective, we know she's a high earner, she's got the capacity to earn money. If she is looking at her a pool of investable assets, how might she approach that?
So I think initially there are some quite interesting considerations in this case to look at.
Yeah.
Where she's been in the UK for 10 years and she has an offshore company in Malta, but she's a UK tax resident. She also has an investment portfolio which is held in Switzerland. So I'd be keen actually to understand from the remittance basis point of view whether she's had tax advice around that, because if you've got all of your earned income in the UK and it's deemed to be in the UK, having a Malta company holding that income could be problematic for the HMRC.
So check the tax structuring.
Yeah, and bring in a tax advisor for sure. I think in her situation for the post-divorce, I think at outset I would want to understand her current income and expenditure requirements. We would use probably our cash flow modelling software to maybe forecast that forward. And you'd think from an investment point of view, would be looking for capital growth rather than income. Given she's young, her soon-to-be ex-husband is young, she's got young children, the use of trusts and making use of the 7-year rules might be a good thing to consider now, because she can move money out of trusts, and part of the divorce settlement could be that there's an agreement that her and her ex-husband, or soon-to-be ex-husband, both have an agreement in place where they make use of the nil rate bands every 7 years for their children for the future, from excess capital that they don't need.
Because she's got a long time horizon. If she's mid-30s, she's looking, I mean, perhaps dealing with sports stars, sometimes their career might be shorter, their retirement plans are different from a conventional office worker. How do you look at the time horizon question, I guess, with a sports star?
It's really interesting, because everything with a sports person is condensed into a really short space of time, where you're almost got their lifetime earnings in a 10 to 15 year period, and you generally don't have real consistency about what you know their income is going to be. So you need to firstly get them to understand that their earnings are going to stop, and that they've got the opportunity now to try to put themselves in a financial position where they've got enough income and capital for the rest of their lives. And ideally you do that without them getting divorced, where they've got all of that asset base. And in this situation, there's going to be quite a considerable trunk that's going to be split between the two parties.
You mentioned their income sources, can get cut short. I suppose as well that's true with media appearances and things like that. It's not certain in a conventional career, doesn't follow the same pattern.
No. And if you look generally in the media, there will only be a handful of people that are chosen for particular roles. And for when tournaments come around, she's in a very fortunate position that she's getting paid a decent income right now, and she is in that role, but we don't know when that's going to end. So we constantly need to understand how that's going, how well she's doing, and have a plan in place to provide income for when that eventually stops.
I mean, given the time horizon, do you think that in terms of the asset allocation, there is the opportunity to invest in equities or investments with a longer term time horizon?
I think you need to understand the individual client's risk. I think conceptually, when you talk to people generally and you talk about investing for the long term, you would look to invest in equities and take on more risk because you've got a much greater time horizon. But generally, sports and entertainment clients are very nervous about investing money and taking risk, because they take risk every day in their jobs, which are high risk. They've got an income that isn't stable. So with the capital that they've earned, they don't like being overly aggressive with that money. And given she does have a lot of money and a lot of wealth, that does she need to take on too much risk with that money, rather than just a solid, stable return above inflation that's going to maintain her capital value over time while still providing her income? But the cash flow planning that we use sort of will determine the level of risk that she might need to take.
And you touched on some of the succession points that she might look at. And following a divorce, people's circumstances have changed from where, if they're married, husband and spouse exemptions can provide some protection from IHT. But what might a newly single person think about in terms of providing for children?
Well, I mean, her children are quite young, and I think one of the agreements in the settlement could be, as I mentioned before, an agreement that post-settlement there is an agreement in place that they'll both make use of their nil rate band exemptions into trust every 7 years. Gifts out of income could be used. She'll need to revisit her wills, her lasting power of attorneys. One thing that's actually quite important here, if she's going to move back to France, she would need wills in multiple jurisdictions, because French inheritance tax and tax laws generally are very different to the UK, and you need to try to have an overriding will that is going to talk to both countries, basically.
And just looking at the husband and his position, if he's obviously in a very different position in that he hasn't had an income, he hasn't got the same asset base, but maybe given a substantial lump sum because there is wealth that has been created. What kind of conversation would you be having with him about how he manages that?
So I think initially there would be an education and planning conversation to have with him. So the cash flow that I mentioned before, I think, is actually more important for him than it is for her, because coming into significant wealth when you've not been earning anything is going to be life-changing for him and probably quite a lot to deal with. So having the planning in place to map out his income requirements is really important. Then from an investment point of view, trying to make sure we make use of all his tax wrappers. So the use of potentially an offshore bond where we can use up his personal allowances, a general investment portfolio where we can use his capital gains tax allowances. So we can probably get him quite a lot of tax-free income from that point of view. From an investment point of view, you'd probably want to have an education session with him to get him comfortable with understanding how equities work, how the bond markets work, volatility, risk, and so on, in creating that portfolio for him.
But making sure he's optimised seems to be the thing. Is
sure.
Use all your reliefs, use the wrappers that you can, get yourself set up and understanding as well.
I think that's probably the first and most important thing in this situation, is making sure we make use of all of his tax-free allowances.
From the divorce side, I mean, understanding how much money you might need is a question the divorce lawyers talk about, and we'll come to Jessica on that. But from the investment perspective, are you often dealing with clients saying, well, with this lump sum, this is the amount of annual income you can expect to earn on different levels of risk?
Yes, we would go through that cash flow planning exercise with them, look at their income requirements, and then we would construct a portfolio where we can try and consistently generate those levels of return to provide that income, so that we're not eating into the capital too much. And that they are very young, so the money's got to last for quite a long time.
And in terms of the pension, I mean, how might that's part of the picture here. So how might that be treated on divorce? I know it's an area you specialise in at Tilney, looking around pension assets.
Well, the pension's the most complicated part of this situation, because given her age, it's likely that she could have a protected early retirement age of 35 if the pension was taken out before 2006. On divorce, if where they could both benefit, the pension's currently £1 million. Therefore, if she were to start drawing on that at this stage, she would have breached her lifetime allowance. So actually looking at potentially splitting the pension on divorce will give them both an increased lifetime allowance. She would actually, on divorce, still retain her early retirement age of 35, whereas her ex-husband would go into a normal pension and have a normal retirement age like 35. However, it becomes quite complicated given the fact that she wants to live in France, because if she were to live in France and look to potentially transfer the pension, which if she's going to stay there long term would be a consideration, she would lose her early retirement age on transfer, because you can only retain it if you do a bulk transfer, which is effectively more than one pension scheme transferring together.
So a lot of considerations there, particularly if she does decide to bring forward that move to France.
And the other big thing with a pension is, whilst the current rules state within the UK it's outside your estate for inheritance tax, whereas the rules are completely different in France. So it's quite a complicated area to focus on, where there'll be needed tax advice around that to see whether moving that pension or doing anything with that pension is not going to.
And if that pension was split, the husband then was entitled to half the scheme, and he went on to go and earn more money, would he be able to add to that pension and use it as his own scheme? So that would
it can still be used in the normal way as any pension would be, within the limits and the annual allowances, providing he had income sufficient to make pension contributions.
Okay. And finally, Adam, I mean, many footballers and other sports stars love investing in property, buy-to-let.
Yeah.
If you come up against clients looking at property as an investment against liquid investments, how do you approach that?
So on the property side, I would try to bring in somebody like Rose to help find properties in the right places. The biggest thing that we come up against is, with sports people, if you take football as an example, when they move around the country a lot, there's a desire to buy a house. And often these might be in places where they're never going to live. So you're constantly having a conversation about whether to rent or not. You might only be there for 2 years. They end up buying a very expensive house. If you're in a smaller area of the country, it's very difficult to sell an expensive property because your market is much smaller. So from an investment point of view, we're always trying to have the conversations with, experts in that area as to buying in, the right areas, the right locations, cities where it's good to rent, good resale, you're going to hold their capital value. And I think the most important thing with property investing compared to conventional investing is some of them want to get into property, but it's always important that they dip their toe in the water to make sure they actually enjoy that, because they need to enjoy being a tenant.
Absolutely.
Or having tenants, sorry.
Sports and media stars, there is a taste for property, for buy-to-let and investment property. Yeah. How do you see that, and how do you help clients who are trying to navigate that?
I think the appetite is there for good reason. When you look back, over the last 10, 20 years, the capital appreciation has been so strong. Back to what Adam said, though, I think it is very important that these buyers are buying well, you know, and that they're getting the right advice, so that if they do want to sell that asset at some stage, that it is in a saleable location, that it's held its value, that it's hopefully appreciated in value, or if they're holding it long term, that it's in a good location for tenancy, because the markets go up and down. You never know when somebody will want to dispose of an asset. But if they buy well at the outset with the right advice, I think they'll always do well.
And in this case, we've seen the sale of a substantial Chelsea property, but inevitably those two new households will then go on and want to reinvest in property. Okay. So you might then help on the acquisition then of two homes that are going to be suitable to have, I guess, children moving between them and things like that. It's quite specific requirements, isn't it?
Yeah. I mean, we often see this, we come across this quite a bit. And, you know, most of our clients are long-term clients. So we will have acquired a property for them, you know, 7 or 8 years ago. They come back and say it's no longer suitable. Will you dispose of it? Will you, you know, handle the sale for us? And in this instance, we'll probably sell the Chelsea house and, as you say, need to acquire suitable properties, especially for the ex-husband in this instance, because I think she'll be moving to France. But, you know, that's part of our business. You know, we're very client focused. The service is there to make sure we understand what the clients need, and then we'll tailor it to them.
And Jessica, just to bring you in order to protect the privacy of those involved, how would you avoid this case from going to court?
So this is a slightly interesting question, which is relevant because the principles behind the family court are beginning to change as it relates to confidentiality. So the core principles of the family courts previously have been that these are people's private lives, these questions involve children, and so it's really important that the facts of most of the cases in the family courts are confidential unless they are extremely important for the sort of public interest. The President of the Family Division, Sir Andrew McFarlane, is beginning to lead a movement, or has already begun a movement, to move towards transparency being a significant priority within the family courts. And that's in order to improve the public view of the family justice system, to make sure that people understand that these things aren't happening behind closed doors and lots of mysteries. With most clients, that's great, because that means we've got more information about the cases that are going through the courts at the moment. But with our more high profile clients, they want to stay out of the public eye. They don't want people to know about their private arrangements. And so we do what we can to keep them away from the court building, so that there's absolutely no risk of any press getting hold of their private information. The decree absolute, which is the document that finalises the divorce, is a matter of public record, but anything else, if we manage to keep it out of the court building, it's private completely, and nobody gets their hands on it. So in any case where you're looking at protecting privacy, the first question would be maybe mediation. So if the parties are on good terms, they're good at communicating, or even if they're keen to try to protect their relationship, we suggest mediation because that allows them to communicate to each other in a safe area where they are feeling like they're being heard. And we recommend that for children matters in most cases, but also for finances, and there's lots of different structures that you can do with mediation. So we could go with them to the mediation so that they feel protected from a financial point of view. If that works, excellent, we can finalise a consent order or other document, sort of terms of agreement as relates to the children. And that remains a private document. If mediation doesn't work, but we still think that they could settle it, but they just need a little bit more of a push, there are some other alternative dispute resolution options. So the first one, and the most popular one, is the private FDR, which is simply a private version of a hearing that you would go to if you were going through the court system. And typically you'd instruct a retired judge or a senior QC who would hear from the parties, hear what their positions are in terms of what they're seeking to obtain for themselves, and then give a view on a without prejudice basis as to what they think the right answer is. And that typically is a really helpful push for the clients to see what their risks are, and most cases settle at an FDR, whether that be private or court. If that doesn't work and they're still struggling to reach agreement, what we are seeing more increasingly recently is arbitration. So that's similar to a final hearing in a children or a financial matter, where it's a decision that is made, it's a final decision, and that's the end of the matter. And that has become more popular recently because of a case that came out where it said that from now on, you are able to appeal an arbitration decision, which previously you hadn't been able to, which was, of course, a significant drawback to going to arbitration, because what if your arbitrator makes the wrong choice? You can't do anything about that because you've signed up to it. So that was the key drawback to arbitration. That no longer exists, which means that increasing numbers of all clients, but particularly high profile clients, are moving in that direction. And that's because of the privacy, but also to try to avoid the significant backlogs in the court system since the pandemic, but also before then as well.
Thank you. And what is the likely split in the asset base of the facts set out here?
So this is a very difficult question to answer effectively. The first question that we would answer with Sandrine is, what is the net value of the assets that are held by both of the parties? So first of all, from this fact matrix, we don't know anything about the husband's assets that he holds in his own name. He might not hold anything, but we don't know, and that is a relevant question for us. And then I'll just explain how we would go through each of the key assets in this case, so that we would be able to find a reliable net value for each of them. So if we start with the £10 million property in Chelsea, first step would be to have that valued either by an estate agent or by a formal expert valuer. We'd look at what the mortgage was on that, but also the tax implications of disposal. So perhaps Sandrine has moved out. Maybe we need to look at what her CGT would be on that if they were to sell it, because it's about what the value is. If you were able to sell it, what would that cash be left over? The second question is the €2 million villa in Provence. So the first step, again, have it valued. What's the mortgage? What are the tax implications of the disposal in France? And are there any tax implications for remitting those net proceeds into the UK? And this sort of question can be quite scary for a client, because they think, oh God, I'm going to have to sell everything, and then we're just going to end up with a lump of cash. And so all of my sensible wealth planning is going to go out the window. That's not what we're doing. We're just trying to work out if everything were sold, what would be left in cash. So it doesn't necessarily have to be structured in that way, but that's the process that we go through when we're valuing the matrimonial pot. Then we look at the €5 million investments in Switzerland. So a key question for that would be to understand the nature of the investment. So what sort of wrapper are they in? And have them valued accordingly. We need to look at what the tax implications, again, of liquidating those investments would be. What would be the tax implications of remitting them into the UK? Then we have the Maltese Trust Company. So it sounds as though this company is almost a personal service company for Sandrine. And so it may be that it has no capital value without her being involved in it. However, if it has cash reserves in there, or if there is some complexity to the corporate structure or the trust structure that owns the company, we need to have a formal sort of expert valuation of that, so that we understand the structure and what the value of that would be to Sandrine if she were to sell it. Again, we'd be looking at the tax implications of liquidating that asset and remitting it into the UK. There's also the matter of the pension. So one of the first questions would be to look at what sort of pension that is, how much there is in there, make sure that we've got a reliable valuation of it, and potentially, depending on what arguments we intend to make, which will all sort of come out in the wash once we know more about the case, potentially have it valued or dealt with by an actuary to give a view on how much it would be worth if you were to start drawing down at X age. So once we've gone through all of those assets, we have a good idea of the size of the net pot. The question is then, how does the law apply to the value of that pot? So the main legislation that applies to the division of assets on divorce is the Matrimonial Causes Act in 1973. So obviously our lives have changed quite a lot since the early 70s, which means that the effect of that law is primarily decided by case law. So important cases that have come up since then. The starting point with any matrimonial fund is it's a division, a 50-50 division of the marital acquest. And you work out what the marital acquest is by effectively putting all of the assets that both of the parties own, whether that be beneficially or legally, into a big pot. So you just think of an idea of a sort of witch's cauldron. You're throwing in all of the assets. You've got the Swiss investments, the Chelsea property. You look at what's in there and you see whether there's anything that you can take out before you divide it in two. And if half of what's left after you've taken out all the bits that you think you can argue, if half of what's left in there isn't enough to meet one of the parties' needs, then you might have to put a bit back in. But broadly, you're lumping everything together and then trying to pick things out or put them back in, depending on who you're acting for. So in this case, it seems that the most important arguments for removing items from the pot would be pre or post separation growth or assets or inherited assets. So we're effectively would be looking at a non-matrimonial argument that either Sandrine was worth X amount when they married, or she's earned since they separated, or that she is inherited, and therefore all of those things mean that some of those assets are non-matrimonial and therefore not available to be divided by two. So the first thing would be to look at the length of the marriage. Was there seamless cohabitation between before they were married and the date of their marriage? So we know that was 12 years ago. Let's say, for the sake of argument, they moved in together on the date of their marriage. So we know that before 12 years ago, that's the beginning of their marriage. So their marriage is 12 years long. Before 12 years ago, given her age now, she'll already have been working, earning money as a tennis player. And so it's quite likely that she'll have been substantially wealthy before their marriage. So what we would be trying to do is quantify what she was worth when they married and see if there's anything in there that's potentially ring fenced. So she's just left in a bank account somewhere or has left in a property, and it's very clear that it hasn't been sort of mingled into matrimonial life. If it has been mingled, that's not the end of the world, but it's much easier to run a pre-matrimonial case if something has been very clearly separate throughout their whole marriage. So we'd be looking for ring-fenced assets. We'd also be looking at mingling. So, for example, if some of her premarital funds or inherited funds were used to purchase the matrimonial home, that makes things slightly difficult for us to argue that it's pre-matrimonial and should be completely excluded, because the matrimonial home is a sort of a very significant asset in most cases, and it's sort of tinged with a matrimonial brush even if it's purchased with pre-matrimonial funds. So that's something that we'd need to know a bit more about. And in terms of her post-separation endeavour, now of course it depends sort of how long they're separated between the date of separation and the date that the final settlement is agreed. But if it's a couple of years, then it's quite likely she'll have been earning significantly in the time between separation and settlement. And if we were acting for Sandrine, we'd be saying that any capital that she's built up from that post-separation endeavour is non-matrimonial and therefore not available for the husband. If we were acting for the husband, we might say something different, but that's an interesting and important question in a case where her income clearly will exceed significantly her actual needs on an annual basis. So she's sort of accruing capital rather than necessarily earning income in that sort of straightforward way. So that's how we would calculate it. Obviously there's lots of information that we don't know, and so it's impossible to put a number on it, but that's sort of how we would go through that, and the process that we go through with Sandrine to try to understand what her risks are and what priorities we should be looking at.
Thank you. And if the children were to carry on living with the husband in London, what kind of maintenance might he expect to receive?
So when the court looks at maintenance, the priority always is for a clean break if possible. So the court understands that an ongoing financial relationship between parties who are no longer romantically involved is not usually healthy. So we try to focus on whether it's possible to allow for the parties to meet their income needs from what they have after the settlement. There's two separate issues when it comes to maintenance. Presuming for the purpose of this question that the children are going to stay living with the husband, he's going to be entitled to maintenance for them, but he also may be entitled to maintenance for himself. So if we look at the spousal maintenance to start with, say, just for the sake of argument, that the capital sum that he receives from the settlement after dividing everything, removing everything from the pot, is around £7 million. If he is able to meet his capital, so his housing needs from that, and have enough left over to invest or otherwise deal with lots of sensible financial planning to ensure that he earns enough income from that capital to meet his own needs, then he's not going to have a maintenance claim against Sandrine. So if we were acting for Sandrine, we'd say, you know, he needs X amount for a house, which leaves Y amount left over for him to invest. That means he is able to meet his own capital and income needs from what he's receiving, so there's no maintenance claim here. If we were acting for him, we might say something different. We might say, based on the standard of living, based on the children's housing needs, he needs this different figure for his housing needs, which means that there's less left over, and that's not enough for him to allow to meet his income needs. So when we'd be looking at arguing that point for either of the parties, when you're calculating spousal maintenance, you do so with reference to the standard of living during the marriage. And that's not the be all and end all, because of course you have to make reference to what's reasonable and what can be paid for. So if Sandrine weren't earning 7 figures, if she had done the more typical thing of a drop off significantly after you stop playing, we'd be making some arguments about affordability, future planning, and that sort of thing. But given that she is earning so much, it's possible that there might be a maintenance here, but we'd be moving away from what is usually called a meal ticket for life, which is a joint lives order, where it provides for the receiving party to receive maintenance effectively until their death or their remarriage. And obviously there are different clauses about that, but that's typically how it's structured. That is no longer favoured by most of the courts. And so the court would be expecting him to maximise his reasonable earning capacity. So depending on what his job was before he stopped work to help with raising the children and running the household, you'd be looking to maximise that. You want him to be retraining, taking some courses to ensure that he's coming back into the world of work. And you wouldn't expect him to do that straight away. So you're not going to expect him to go straight back into high earning or the earning that he was doing before he quit his job before, without some time for adjustment. So what's typically the structure here is that there'll be a step down. So for a few years or until one of the kids is in secondary school, or something along those lines, it will be at this figure. And then as his life develops, as you expect him to be promoted and move into full-time work, that will be then stepped down. With a view ideally to it reducing to zero within a reasonable number of years. Usually you sort of pitch that at the time that the children go to school, but it might be earlier than that, it might be later than that, depending on the circumstances in this case. There's also the option for Sandrine to capitalise that maintenance. So if he is successful in arguing that he does need maintenance from her, she may take the view that she'd rather just give him a little bit more capital in order to remove that claim against her in the long term. So you might just sort of bump up his capital award in order to ensure that there is enough there for him to meet his income needs from his own assets. And then we come to the children maintenance, and this is different to spousal maintenance in that it's not focused on needs per se. The sort of standard principle is that it's a portion of the paying parent's income. This question is complicated by how much Sandrine is earning. At 7 figures, she is well outside the jurisdiction of the Child Maintenance Service, or CMS. And as she's planning to move abroad, that will also take her out of the jurisdiction. So what we would want to do to keep things as simple as possible is deal with the matter of the child maintenance as part of the divorce process. So it's all sort of wrapped up in the same order, and both parties have very clear visibility of what their position is. With the higher net worth individuals, this used to be a lot more difficult. You'd have to do a similar thing. You'd have to quantify the needs of the children. You'd have to look at school fees and uniforms and what sort of extracurricular clubs they were doing, and that sort of thing, which wasn't actually a proportionate use of the legal fees that incurred. And so what happened in 2019 on a case that we acted on was Mr. Justice Mostyn, as a sort of passing note within a larger judgment on a different sort of case, made the comment that for the higher net worth individuals with higher incomes, the child maintenance formula should still be a starting point for calculating the children's maintenance, even when they're outside the jurisdiction of the CMS. So what he said was that in every case where the gross income of the paying parent is up to £650,000 a year, you simply use the same formula as the CMS formula, with a view, we think, to simplifying the higher net worth cases and trying to keep them out of court, because it does seem as though the judiciary were a little tired of having to decide who pays for the socks and who pays for the school lunches. And so I think he just said, we're not doing that anymore. This is what the rules are for anything up to 650. Obviously, Sandrine is earning more than that. So he did deal with that as well in his judgment. He said that for anything over 650,000 per annum, you take the 650 figure as the starting point, which in this case would be around £5,600 pounds per calendar month. And then you depart from that figure with regard to the scale of the excess, so how much she is earning over that £650,000 per annum. Again, it's very difficult for me to put a figure on this without knowing more about what the children's lives are like. So how expensive their hobbies are, for example, and what sort of lifestyle they have lived throughout the relationship between their parents. And so it's a detailed and very needs-based quantification exercise, but that would be how we'd calculate it. So, 10, 12, 15,000 per calendar month. It could go anywhere between all of those, depending on Sandrine's income and what life looks like on the ground for the kids.
Thanks. And as Sandrine is considering returning to France, how would custody and access arrangements work should she decide to do that?
So this, again, is a very difficult question to answer. What I would say first is that we don't use the words custody and access in children proceedings anymore. It's sort of gone out of fashion, but it's also not what we're supposed to refer to the orders as. So rather than custody, we say who the child lives with, and rather than access, we say who the child spends time with. And that's part of a movement within the court systems to seeing children as human beings rather than sort of property. So it's not about who owns the child or has custody of the child. It's about it's trying to make it more child-centered, child-focused, so that you're looking at what life looks like for this child. And that's a theme that will colour what I'm about to say about how this would be decided. So the first question I think we need to establish, which isn't clear, is what Sandrine actually wants to happen if she moves to France, whether she wants the children to come with her or whether she wants them to stay in London and wants to make sure that there's some regulation of how often she sees the children. So if she wants the children to go with her, that's absolutely something that we can try to do. We would call it a relocation application, and the court would take a very holistic view of that sort of question. So the court would want to know what the child's life looks like if they move to France. Where will they go to school? Do they have extended family around there? How will they spend their spare time? Where are they going to live? But also, and importantly, how is Sandrine going to continue to facilitate a close relationship with their father? So she'll have to come up with a plan for how often they will see him, and a lot of indirect contact, and also encourage an ad hoc communication between the parents, so that if he is in France for whatever reason, or if she is coming to London, that they can facilitate some ad hoc contact between the children and their father. As always, you're looking at what the best interests of the children are, and so that is going to hinge very significantly on who the children are, because no child is the same, and depending on their age, they are still quite young, but there will be there might need to be some exercise in working out what they would like to happen, so that their best interests can be protected by the court or the mediator or the arbitrator, or whoever makes the decision. If she doesn't want to take the children with her, their primary carer is their father, so she might want to allow them to keep that consistency and keep their life the same on a day-to-day basis. Then we'd need to understand a lot more about their lives, her life, her work calendar, where they go to school, what their holiday structure is, how often she can come back to London to see them, how often she wants them to go to spend time with her in France. So we'd be looking at perhaps facilitating some regular weekend contact where she comes to London or they go to her, and also condensing some of the contact that they're losing with their mother into school holidays. Now, it's not going to be every holiday, all of the holiday with mum, because she's not seeing them during term time, because it's also in their interest to be able to spend some holiday time with their father. But you would be looking at trying to sort of condense that contact into holiday time when they're not in school. And as I mentioned earlier, if they can't agree on this, then mediation is a really helpful venue for deciding children disputes, because it works to maintain and preserve the communication and relationship that the parents have already, which, when it comes to ongoing co-parenting discussions, as I said, ad hoc discussions about short-term, sort of just on a whim contact with the children, it's really important that they are able to communicate about that in a positive way without it becoming toxic and sort of affecting the children and their relationship with either of their parents. So that's something that we choose mediation for, but it's also something that we keep an eye on during all of the other discussions that we would be having about the finances, what we can do to make sure that we are protecting the parents' relationship, because that is one of the major assets that they have, and it's extremely important for the children.
Well, thank you very much, Jessica. Thank you for joining me today. If we were in a situation where Sandrine was calling you up, she set out the case, she's explained the situation she's going through, you've got a coffee with her next week, Adam. What are the things in that first meeting you think you'd want to understand, and what would you try and find out and leave her with about how you could help her?
I think that the things I would want to know are how strong is her desire to move back to France. Is that set in stone that she's definitely going to move to France, full stop? And if she is, at that point we need to bring in a French tax advisor and a French lawyer. And I think we need to talk in detail about her Malta company where she's earning money at the minute. I think we need to understand more about her investment portfolio in Switzerland and how that's been managed. And I think we have to have a very long conversation, as I mentioned, about what to do with her pension, given the fact that she's got this protected early retirement age. So I think they're my areas of concern. Outside of that, there's the normal planning requirements. So how long does she see herself working in the media for? Is it a long-term thing or a short-term thing? Does she want to continue that in France? Is it UK-based only? And then what are her long-term income and expenditure requirements? Understanding more about schooling in France compared to the UK and how that's going to be taken care of, which, sort of falls into the custody issues which we've been discussing earlier.
Thank you. And Adam, if Sandrine's husband contacted you looking for financial advice, what are the sort of things you would want to talk to him about in that initial meeting?
I think for him, I'd be interested to know whether he plans to return to work, because if he's been a full-time carer, probably due to the fact that she was playing tennis around the world. So, but is he going to work again? And if he's going to work again, what's he going to do? So therefore, does he have immediate requirements now for income, or are they more for the longer term? They would be the main things at outset. as well as I think he will need a little bit more nurturing and educating around investments and maybe financial planning.
Perfect, thank you. And Rose, if Sandrine calls you up, she wants to have a coffee next week and chat, you've got the fact pattern, what is it that you'd want to be discussing with her in that opening meeting?
I think in advance of that meeting, I'd have a chat with Jessica just to understand at what stage we're at in the process. You know, is there a settlement agreement in place, and therefore perhaps there's already consensus around, you know, values and timings and so on. And if all of that is in place, then it's just really understanding what's important to the client in terms of service, how she'd like us to communicate with her, you know, understanding a little bit more about explaining the process to her and what she expects as well. So getting to know her a little bit more. I'm guessing that, you know, Jessica will have everything in place and in order. We'll take it from there with a plan.
Great. And Jessica, if Sandrine was to contact you about the divorce case, what is it that you would advise her in that initial meeting, or what is it that you'd want to find out more about?
So in a first meeting with any client, our first thing that we discuss is what their priorities are. What do they want to achieve? What are their most important things? What are the things that they don't actually care about, but maybe we can use in negotiations? That's the key conversation in that first meeting, because what my priority might be as their lawyer, i.e. protect the money, make sure that the decisions about the children are the right ones for my client with a view to what's in the best interest of the children. Their priorities might be different. So Sandrine's priorities might be, I don't care about the Switzerland investments. He can have all of those, but my priority is making sure I have access to I have got sort of contact with the children as much as I would like. Then that might mean that we strategize slightly differently in terms of what goes first, what's our priority, what are we spending the most time on, and what are we letting go in order to sort of pick our battles. So that's a very significant part of that first meeting, to make sure that we're all aligned with what our plans are. Also, with a more high profile client, a key issue within the first meeting is a sort of risk assessment in terms of reputational issues. So making sure that there's no risk that he has access to incriminating pictures or some sort of scandalous information as part of the breakdown of the relationship, and he's feeling angry and he wants to tell the press about it. So we would be doing a sort of risk assessment at that stage. Is there anything that is going to come out? Do you want us to do anything to try to prevent that? And we have a reputational team here who we often refer our higher profile clients to deal with that sort of issue. So if we were meeting with him, the answer is broadly the same. It's a question about what his priorities are. We might not have so much of a focus on the reputational issues because, of course, he's not as well known. And so it's possible that there might be some scandal that might come out that might affect him or the children. But broadly, that's something that we deal with the high profile individual themselves. What we would talk to him about that we wouldn't necessarily talk to Sandrine about in such detail is his financial security in the time between separation and the final settlement. So first of all, is the house in Chelsea in their joint name? So is he named on the title of that property? If not, if it's just in Sandrine's sole name, or if it's in a trust or any sort of complicated structure that means that he doesn't actually own the legal title in his home, we would be looking at protecting him by placing a notice on the land registry title to prevent the sale of the property out from under him, so that we know that he's protected, he's got somewhere to live until we can work out what the longer term plans are. We'd also be asking about his cash flow. So does he have cash in his own name, or does he rely on maintenance from Sandrine to maintain himself and the children? If the latter, we'd be looking at trying to formalise that arrangement so that he has security. So we'd be looking at what's called maintenance pending suit or interim maintenance, to make sure that he feels secure in his monthly income needs going forward in the time between now and the final settlement. And that figure is likely to be less than the final figure for his income needs, whether that's paid for by his own capital assets or through a maintenance order. because obviously it doesn't include contributions to slush funds and that sort of thing. You're looking at just his very short-term needs, so items for the children and bills and that sort of thing, but also a couple of holidays, because everyone deserves a break. So that's what we would be talking to him about. And if we can't agree with that, if we can't agree that with Sandrine, then we'd be looking at making an urgent interim application for maintenance for him. So similar but different, a slightly different angle for the financially weaker party.
Thanks very much.